permission.
Okay, perfect. So we have about 8 attendees. We can wait a couple minutes, and if you'd like, Julie, just to get some more folks signed on.
Sure, yeah. Hey everyone, while we're waiting for others to join, I was wondering if any commercial tenants who are joining today could write where your business is located or the city you're from in the chat. Just so I have an idea of where people are located and where it would be helpful to focus on today. Okay, I see a San Francisco. Couple San Franciscos. And also while we're waiting a couple minutes, I was wondering if those in attendance who are commercial tenants or service providers could write some questions you have or what brought you to the webinar today. So I see mostly San Francisco and also in Oakland, so that's good. I focus on those two areas in the webinar, but yeah, if you'd like to type in any questions you have or what brought you here today, that will help me know what to focus on as well. And we'll get started in just a minute or two. So I'll be checking the chat periodically if any of you want to write an answer. But in the meantime, what I thought might have brought you here was the sort of wondering. So the commercial eviction moratorium expired on September 30th, 2021. Now what? And I'll be talking about some protections that still remain in jurisdictions like San Francisco or parts of Alameda County, and also give an overview of the eviction process for those of you who are concerned that may happen to you and have questions about the process. So let's see, somebody did write into chat. He's wondering if the state is working on any type of forgiveness program for unpaid rent for landlords and tenants. That's a great question. And yeah, I'll review the chat periodically to see if there's any more questions. So first of all, my name is Julie Gilgoff. I'm a staff attorney at Legal Services for Entrepreneurs, which is a division of the Lawyers Committee for Civil Rights of the San Francisco Bay Area. It's a pleasure to be meeting with you all today, although I wish it was for happier reasons. And hopefully this webinar will answer some of your questions and provide some information that you're looking for. As a disclaimer, nothing in this webinar should be construed as legal advice, just providing legal information. Everybody's case is so individualized and specific to your own circumstances. So please, whenever possible, seek individual legal advice. And I'll be giving more information later on about legal consultations that are available through our organization or some partner organizations and how to go about applying. So in San Francisco, where I see many of you are from, the forbearance period is still in effect. The Board of Supervisors ordinance created 4 tiers of tenants. And for those of you who already know this information, let's just review for others. Many of you are tier 1 tenants, which means that as of November 2020, you had 10 or fewer full-time employees. And so for your business, you have 2 years to repay all the deferred rent, all the rent that's accumulated between March 2020 and September 2021, you have 24 months to repay that rent. For tier 2 businesses, which means you had between 10 and 24 full-time employees, you have up to 18 months to repay all the rent. Tier 3 businesses and tier 4 is listed on the slide, which, by the way, we will distribute to all the participants. Mayor Breed signed an amendment. At first, those businesses with 50 or more full-time employees had to pay all the deferred rent once the moratorium expired on September 30th, but Mayor Breed just signed an amendment, which will go into effect in a few days on October 24th, which allows commercial tenants with 50 to 99 employees up to 6 months after the moratorium expires to repay any missed rent. So what the forbearance period means is that nobody who was unable to pay all the rent, which accrued between March 2020 and September 2021, should be evicted for non-payment of rent for the rent accrued during that period. So it still means that that you are at risk of eviction if after this point, beginning October 21, you can't pay the full rent going forward. And it also, you are also at risk of eviction if during this time your lease expired, and therefore your landlord has the right to terminate your lease by giving 30 days notice. So just going over some of the areas that the commercial eviction moratorium did not protect against. I see I have another question, or so somebody's asking about an individual circumstance, so I'd be happy to answer questions a little later on about your individual questions. Let's see, just to go back and see what we missed. These are some additional protections that remain in San Francisco. There is there's a presumption that was passed by the mayor in San Francisco, which provides certain commercial tenants with a rebuttable presumption that you may raise during court proceedings. And this, the presumption states that if your business was required to completely shut down during the pandemic, which means that you're a business like a barber shop or salon or spa, which unlike restaurants could be open in a modified way, but if you are required to be completely shut down by court, by government mandate, then you are not required to pay any rent during those months. And that's a defense that you can raise if you have an eviction lawsuit against you, that rent should not have accrued for those months specifically. And by the way, that presumption is being challenged in court, but so far it is still in effect. We went over this. In Alameda County, there's generally not as many lingering protections, unfortunately. So according to the City of Oakland website, and I've hyperlinked to each of the sources, which when you get the presentation, I welcome you to click on each of these websites, like OEWD in San Francisco or the City of Oakland Small Business Center. There's a lot of resources, including funding sources that are available, and also updates about any protections available. So according to the City of Oakland, the protections that prevented commercial evictions of small businesses and nonprofit organizations for non-payment of rent ended on September 30th. Back rent may be due in full beginning October 1st, 2021, depending on the payment plan or other agreement negotiated between the tenant and landlord. And one of the purposes of this webinar today is just to emphasize that it's not too late to try to negotiate a repayment plan or agreement if a lot of rent has accrued, especially if you're in the City of Oakland that doesn't have a forbearance period. We have suggestions along the way about negotiating a repayment plan so that you and your landlord are on board with, let's say, paying the full rent going forward and making monthly contributions to make up the back rent. So we still encourage you to engage with your landlord to try to come up with an agreement before an eviction lawsuit is initiated. The City of Berkeley does have a forbearance period similar to San Francisco. It gives up to 12 months to commercial tenants to pay deferred rent that was accrued during the pandemic. And if you're sued as an Alameda County resident, you have a great resource, which is the Alameda County Superior Court Self-Help Center. And it's, again, there's a link there, which offers phone and video consults as well as live chat feature. And they can help you write an answer to a complaint if you have a lawsuit initiated against you. And also, Alameda County Bar Association offers referrals to private lawyers. Of course, you're also welcome to apply for our services, and the link for our services will be at the end. So this slide asks, what happens if you are sued, what to expect. So this webinar gives an overview of the unlawful detainer process, not breach of contract lawsuits for non-payment of rent or any type of lawsuit. And just so you know, in California, a lawsuit to evict a tenant is called an unlawful detainer. So regardless of the jurisdiction, your landlord can't physically remove you from the property or change the locks without going through this lawsuit process. The landlord must go to court to evict you. Yes, we will definitely share the slides after the presentation. If you receive a 3-day notice or a summons and complaint for a UD or unlawful detainer lawsuit, you should contact an attorney immediately. This is such a short timeline that we're dealing with. And this webinar just gives an overview of the timeline you're expected to respond in. So if you are a sole proprietor of a business, you have the option of filing the answer yourself or representing yourself in court. If your business is an LLC or any type of corporation, and the business was named on the eviction papers, you need a legal representative to file these documents and can't do it on your own, unfortunately. So the first step in the eviction process or a UD process is the 3-day notice to pay rent or quit. As soon as the tenant fails to pay rent, a landlord can give the tenant a 3-day notice. This notice must inform the tenant that if the tenant does not pay rent within 3 days of receiving the notice, then the landlord will begin the eviction process against the tenant. And the 3-day notice to pay rent must be written, and it must include the following information: the date the demand was served on the tenants, which means the date it was delivered or mailed, names and addresses of the tenants, a statement that the tenant owes rent and must pay it within 3 days, or the landlord will file an eviction lawsuit with the court, the total amount of rent due, the name, telephone number, and address of the person who receives the rent payment, or that's usually the landlord or the landlord's agent, along with the days and hours that the person is available to receive the rent. Even if you already know this information, the landlord must state it in the notice or the notice is defective, and a certificate of service specifying how the demand was given to the tenant, or how the notice was given to the tenant. The notice can be served on the commercial tenant, or this means the landlord has to deliver the notice either personally, somebody needs to give it to you personally, or somebody needs to leave it with either you or someone else in your workplace. And then in that case, if they left it with someone besides you, they'd need to mail a copy directly to you. And if no suitable person can be found, then the landlord is able to affix a copy in a conspicuous place on the property. So for example, they can hang up a copy of the notice on your door of your workplace, and they also are required to send it through mail addressed to the tenant. And we're giving these requirements so that you could look out for them. And if there's any defects in either the way that the notice was written or how it was delivered, this could be asserted as a defense, and some people have their entire cases dropped or at least delayed as a result of these defects. So you must respond. These are different ways that you can respond to a 3-day notice. You could either pay the rent in full within 3 days of receiving the notice. This is easier said than done. In that case, the landlord can't go ahead with the eviction case. You could at this point still negotiate with the landlord to see if a rent repayment plan could be agreed upon to avoid a lawsuit. So it's still, even after receiving the 3-day notice, it's not too late to negotiate a settlement. It's still outside the realm of the court system at this point. Another way to respond to a 3-day notice, you could move out of the unit within 3 days. If you can't pay all the rent that's due, the landlord will use your security deposit to cover some of the rent. And then they will most probably sue you for the unpaid amounts of rent, but then at least you won't be in the space anymore. Usually that's not possible within 3 days since of everything you have stored in the unit, but just to tell you your options. Another option would be to not pay rent or move out. And in this case, the landlord would proceed with the eviction at the end of the 3-day period. And just to go over additional potential defects in the 3-day notice or what is permissible, the landlord can include just a reasonable estimate of the rent that's due as long as they say in the notice that it's an estimate. So a defect in the notice is not that they don't have the exact right amount as long as it's no more than 20% more or less than the actual rent that's due. If the tenant is unable to personally deliver the rent amount, this is just to tell you, let's say you can hypothetically, like you just received a large loan, you can pay the rent that's due. And if the landlord hasn't received it within 3 days, you just need to show proof that you mailed a check, let's say, and then that will it should still prevent the landlord from initiating a lawsuit. And if the rent is to be paid at a financial institution, if that's the instructions that the landlord left in the notice, it must be located within 5 miles of your commercial rental property. So if it's farther, that's a defect in the notice that you can assert. So let's say after the 3 days, the rent wasn't paid, the eviction lawsuit goes ahead. The first step is the summons and complaint for the unlawful detainer. The plaintiff landlord may file a claim with a small claims clerk at your local court and have a copy of the claim or the complaint delivered to you, the defendant. This is called, the proof of delivery is called service of process. No lawsuit is complete without it. The reason that they must serve you is obvious, that you, the defendant, need to know about any claims against you and must be notified of the day, time, and place that you can show up to defend yourself. So we have had clients already come to us who were not served with their summons and complaint, but they still learned that there is a lawsuit pending against them. So you still do need to get a lawyer that still is a lawsuit against you. So just because you haven't been served, don't assume that you have no liability, but this just means that the landlord is required to try at least 3 times to locate you. And so it is going to delay it, but not necessarily make the case go away if they can't find you to deliver the summons and complaint. The summons and complaint, just to tell you more requirements for the landlord, there are 2 separate court forms that they need to deliver together. The summons and complaint must be filed using official California court forms, and those court forms are hyperlinked to these slides. If you do get a summons and complaint, just double check that the landlord has used the correct forms. So normally tenants only have 5 court days after receiving the summons and complaint to file the answer with the court, unless it was delivered through substitute process, which I'll explain on a later slide. If you don't answer the complaint in the time required by law, a default is entered against you. This means that you can't defend yourself in the case and you may be forced to move from the property. And another warning is that if you have a default entered against you, this will show up on your credit report and make it harder for you to rent another space. So we really encourage you, if you get these papers, you need to respond within the time frame. Let's say, for legitimate reasons, or just you couldn't get around to it. You did not respond within 5 days. Still seek legal help, definitely, and the lawyer might be able to help you file a motion to set aside the default judgment. And so you still could go ahead with your lawsuit. Just seek the assistance of an attorney as soon as possible. These are some requirements for the way that the summons and complaint must be delivered. The landlord can deliver eviction notices to tenants through personal service, substituted service, posting it on the door and mailing, or in any way that's outlined in the lease. So read your lease to look over if it outlines the service requirements. landlords must attach a civil case cover sheet, which is this hyperlinked form, and deliver it with the summons. Otherwise, it's a potential defense of why the case should be dropped. So this is a lot of information. The point of this slide is just to go over what does substitute service mean, to be on the lookout for it. You know, personal service is when the landlord or a hired process server or any person over 18 directly delivers the eviction notice to you. Substituted service is when the person delivering the eviction notice leaves it with someone else because you weren't there at the time of delivery. And if substitute service is used, then you have, instead of 5 days to answer, you have 15 days. So that's why it's an important distinction to look out for. If you receive a UD summons and complaint, and you're trying to count whether you have 5 or 15 days to submit an answer, you never count Saturdays or Sundays or any official court holidays, and these are listed on this slide. So coming up is Veterans Day on November 11th, and then Thanksgiving, the day after Thanksgiving. So these are just some court holidays to be aware of. So I see Anna has a question, and I'd like to go ahead with answering questions along the way rather than waiting till the end. So Anna, can you ask your question? I'm not sure if you're able to speak, or I can just read it for you. So Anna's question was, can you tell us more about the rent repayment waiver or for businesses who were forced to close completely during shelter-in-place order? Do you have any official notice from the mayor for this? Can we request the landlord to pay us back the rent that we already paid for months that we were closed? So that's a great question. I'm going to go back to a couple slides to answer your questions. So, and also just answer, you can't go back and request the landlord to repay for the months that you were closed and you already paid. Unfortunately, this is just a defense to be used in court if you're sued for eviction. So, you know, that's an outcome that you want to avoid. And I know that this doesn't seem fair, since you may have, you know, you went into debt to make the payments, but you can't be reimbursed for them at this point. Just going back to the rebuttable presumption, there's a link here which says you asked for, you know, proof about the presumption, and Anna, it might be worth it to make a printout of this defense, which I'm linking to now. I'm not sure, is everyone able to see this page, or is it staying on the slides? You can see the City and County of San Francisco Board of Supervisors link, or no?
Yeah.
Hang on the slide,
Oh,
Julie.
not the link. We can
Just-
still see the slide.
Okay, cool. So I'm gonna stop share and I'll just reshare with that link. Thank you. So this is a copy of, this is all that's available in terms of proof of the legislation. This is an ordinance amending the administrative code to establish a rebuttable presumption that a commercial tenant who was legally required to shut down due to COVID-19 may be excused from having to pay rent that came due during the shutdown. So Anna and everyone else, I don't believe, you know, I think that the landlord is going to do their research and assert that they don't have to reimburse the rent that's due, but it shouldn't stop you from making that request, in my opinion, because this is such unprecedented times and the landlord might agree to it. You might just be able to use the presumption as leverage to get them to forgive some of the back rent if you have any back rent that you didn't pay, or even to reduce the rent going forward, because we know that, you know, this just because, you know, beginning October, This month you're expected to pay full rent going forward, and we know that that's really not doable for many businesses who haven't resumed a normal capacity. So I think that you should try to assert that defense and just see what they say. But it's my legal opinion that they're not required to reduce the rent or reimburse you. So moving ahead, let's see if there's any other questions. I think that's it for now. So yeah, these were the court days and holidays that don't count when you're calculating when you need to submit the answer. If the tenant was served in person or personally, the tenant has 5 days to respond. Again, don't count Saturdays or court holidays. If the tenant was served by substituted service or post and mail, so if nobody served you personally, then you could assume that you have 15 days after the date the server mailed the court papers to file a response. And this is more information. The way that you could tell if it counts as substituted service too is that the server must write up a declaration of due diligence, which is a document for the court detailing every attempt he or she made to serve the papers in person. So usually the server needs to try personal service 3 or more times before substitute service can be resorted to. So you'll know if you have 15 days as compared to 5 if there's a declaration of due diligence that accompanies your summons and complaint. So finally, this is information about drafting your answer. California has a standard answer form, which is hyperlinked here, UD 105. This form must be used by a person who is a named defendant in the complaint. If you're a sole proprietor, again, you can fill out this form and file it yourself. If you own a business that is anything other than a sole proprietorship, like an LLC, you need an attorney to file this form for you. Either way, it's preferable to seek legal counsel if that's possible. The answer should contain denials if you think that something written in the complaint was incorrect, as well as affirmative defenses, which are defenses that the law recognizes and which all must be stated in the answer in order to be considered at trial. So denials are more details about how to write your denials. When you read the complaint, you'll see a list of numbered statements as mini paragraphs. If you think that one of these statements is not true, you can deny it on this form on your answer. You have to deny it if you don't want it to be considered true. If you don't deny, the judge will think you agree. And if you look at the UD 105 form, you can deny something by listing the statement number in item 2 in your amended answer, which is just a longer version of the answer that's not using that court form UD 105. Since many of the defenses listed on UD 105 pertain to residential tenants rather than commercial tenants, you should skip over the initial defense boxes, which talk about habitability and other defenses that unfortunately don't apply to commercial tenants. And then just check box 3B on page 4, other affirmative defenses, and then you have to explain every defense under 3W. If more room is needed, you should explain everything on form MC 025, which is linked to these slides. So these are more examples of defenses you could assert in your answer. If you've ever attended one of our commercial lease webinars in the past, we've discussed potential defenses like commercial frustration of purpose, or force majeure clauses, which say that an unforeseeable event, such as the pandemic, should excuse you from paying rent. Commercial frustration of purpose means that in your lease, it outlined the purpose of your lease or of your business. And it says if you can't carry through these purposes of your business, then your lease no longer is valid. So these are potential defenses that we suggest you assert in your answer. And then again, if you're a San Francisco commercial tenant, you should assert the presumption, which we went over before, saying this only applies if your business was forced to completely shut down by government order, not if you were allowed to open in any modified way during those months. You may also assert a defective notice or a defective service in this section, which we've went over. You may qualify for a fee waiver if you fit into any of these requirements. If you receive public benefits like Medi-Cal, food stamps, CalWORKs, general assistance, SSI, etc., you automatically qualify if you just show proof that you receive those benefits. You have to fill out these forms, the FW001 form or FW003 form, which are hyperlinked here. Or you can just simply assert, and the court would have to determine that you don't have enough income to pay your household basic needs and the court fees. Just the filing fees are usually about $200, but there are other fees associated, just so you have that frame of reference. The fees depend on which jurisdiction you're located in. So, and all that information is on the Superior Court site. And usually they have a help desk that you can ask these questions to. So if you're a sole proprietor, again, you're the only class of business that can file these forms on your own. But if you are filing on your own, make sure to make copies of every form, including 2 copies of your answer. And then you have to serve correctly, just as the landlord was required to serve upon you according to law. So you should ask an adult at least 18 years of age who's not a party in your case, so they can't be a joint owner of your business, to fill out and sign the proof of service after filling out UD 105, which is the answer form. That same person should also mail the documents to the landlord or the attorney. You have to fill out this form, which is proof that you have served or even just mailed it. And then after all this, you don't need to submit a copy of your fee waiver request. You need to, with the photocopies and the proof of service form, you need to file it with the court. So this could either be at the Superior Court at the address listed on your complaint, and you may be required or permitted to e-file. So again, you need to check on the San Francisco Superior Court or Alameda County Superior Court website for their requirements. So after you filed your answer, your landlord can file a request to set case for trial. This is the form UD 150. Usually it's within 20 days of when, 20 court days after your landlord files the request. That's usually when your trial date can be set for. We don't know in these unprecedented times if the courts are going to be inundated with cases that it will be much more than 20 days. Other ways that you might delay it, or other reasons that it would be more than 20 days, is if your landlord requests evidence from you or discovery requests. Your landlord will, in the court case, present evidence, and you also have the right to present evidence, things like emails between you if the landlord agreed that you could have longer to repay the rent, any letters that you submitted or that you received indicating that you would not be sued in this way. So you should bring them to your court date, make copies so that you could give a copy to the judge, one to the judge and one to the other side, your landlord or your landlord's attorney. If your landlord is requesting all sorts of evidence from you, like all your financial statements, your bank account information, you're not required to give them if you don't think it's fair. And again, this is a question for an attorney, but if you're a sole proprietor representing yourself, these are examples of objections that you can raise if you don't think that the requests are fair. You can say that it's irrelevant to see all your bank information. That's not relevant to the subject matter of the commercial eviction. You might object because it's confidential information. You might say that it's an undue burden if they're requiring like receipts from all these months that you just haven't collected. You don't have to gather them. You can just object to what's being asked of you. You can even object to information being requested if it's an unwarranted annoyance, embarrassment, if it's oppressive, or if the landlord is just asking to intend to annoy or harass you. That's another defense. You have the right to call witnesses to help your case if you think there's anyone who can speak to, your side of the story. Or for example, we've had clients come to us already who have asserted that the landlord has offered rent repayment plans to all their other tenants except for them. Some of them feel like it was racial or ethnic discrimination. And some tenants even have other tenants who are willing to testify on their behalf. That would be very helpful to your case. So on the day of your trial, the judge may ask you and the other party to step outside the courtroom, even at that late in the game, to discuss your case to see if you can agree to a settlement. If you settle your case and if you make an agreement, don't leave the court without a copy of the agreement. Don't wait to get a copy in the mail. Tell the other side that you'll wait in the courtroom for a copy. Having a copy helps to prevent misunderstandings during a stressful time. Just additional advice. Once you and your landlord have had the chance to present your case, the judge will make a decision, and they'll usually tell you what will happen next. The court clerk will give or mail you a copy of the judgment. If the judge or jury decides that the landlord has the right to evict you, the judge will give the landlord a judgment of possession. They may also order you to pay back rent, damages, penalties, and costs like filing fees of attorneys. Usually you'll know this ahead of time if it's in your lease agreement, if you could be required to pay their court fees. So the final steps in an eviction case, if the judge rules against you, again, the court will give the landlord a judgment of possession. The landlord will fill it out, and the court clerk will issue a writ of execution, which the landlord will take to the sheriff's office. This gives the sheriff permission to lock you out. The sheriff will first serve a notice to vacate, and this gives you 5 to 7 days to move out. If you don't move, the sheriff will remove you and your possessions and lock you out. You can ask the court for more time to move out, and this is called a stay of execution if you have a good reason that you need more time. The stay of execution will last up to 40 days, but usually not more, and you'll owe rent for each day that you stay during that stay of execution. These are some lawyer referral suggestions. Of course, all webinar participants from the Greater Bay Area may apply for services with our organization, Legal Services for Entrepreneurs. If you're sued as an Alameda County resident, the Superior Court Self-Help Center offers phone and video consults, as well as a live chat feature. We at Legal Services for Entrepreneurs do our best to get back to clients within 3 business days, but if you see that we're not responding, you need to seek outside help. So please don't assume that just because you've written us an email or even submitted an application, if nobody's gotten back to you, you need to look for alternative resources. Alameda County Bar Association offers referrals to a private lawyer. San Francisco Bar Association lawyer referral program. And then mediation support is still very important, as we emphasized, to help reach a settlement even after receiving a 3-day notice. Before receiving a 3-day notice, at this point, we suggest that it's not too early to try to negotiate a settlement or an agreement for how the back rent will be repaid. And we have the link to conflict intervention services to help reach such a repayment plan. They're great at getting both sides to come to the table. And a little bit later on, I would love for someone from conflict intervention services to come on and tell us a little bit about their services. But in the meantime, I wanted to introduce the senior attorney at LSE, Jasmine Poyowan, who is on the call with us today. And she wants to share a little bit about her negotiation experience as well. And afterwards, just go over a timeline of the UD process. So thank you, Jasmine, for joining us.
Thank you, Julie. That was very comprehensive. I don't know how much I can add to the UD process. I think Julie did a great job outlining sort of the steps a landlord must take. So a lot of folks don't realize this, but the lawsuit can't just be filed or slapped on you. There needs to be 3 days, 3-day notice, sometimes more depending on your lease. So the biggest advice and takeaway I hope that folks get from Julie's presentation is just really understanding your lease, understanding your rights under the lease, and understanding that landlords do need to follow a very specific process if they do opt to evict you. So with all that said, unlawful detainer process is very, how can you call it? Can be very lengthy, can be very stressful, can be expensive, especially if you have an attorney or if it's a complicated matter where there's a lot of discovery. So what Julie was explaining, like if there's a lot of information that needs to be shared between both sides. And so really what I have seen in my own experience is the goal really is to negotiate and reach some sort of settlement with your landlord and avoid trial, avoid a lawsuit at all costs, because lawsuits are expensive. And when you're already in a situation where you're paying for rent or struggling to pay for rent, it's just not a great option. And so a little bit of background for myself, I just started at the Lawyers Committee for Civil Rights about 3 weeks ago. Prior to being with the Lawyers Committee, I was directing attorney at the East Bay Community Law Center's Community Economic Justice practice, where we did very similar work, advised commercial tenants, helped small businesses, entrepreneurs, sole proprietors. And from my experience in negotiating different contracts, whether it be a commercial lease, whether it be a procurement contract or an employment contract, I think there are some basic principles that apply and can be hopefully helpful for tenants here on this webinar to remember when approaching their landlord. I saw someone had mentioned in the chat that they had already kind of sent a proposal to the landlord, and that's great. I think that would be my first piece of advice, is to, one, reach out to your landlord. And for a lot of folks, I think the first step even is before that, understanding who your landlord is, whether the landlord is just a small business person themselves, or whether it's you're dealing with a property management company. Just really understanding who your landlord is in order to understand sort of what your landlord situation is. Does your landlord have a lot of commercial tenants, commercial spaces? I think that just changes kind of the landscape of the negotiation, understanding who you're negotiating with. Because the number one tip I have in all negotiations is just really understanding what interests the other side has, and aligning those interests, figuring out how to align with those interests. And to align with those interests, you need to understand what your interests are too. So I think that's the number one thing I ask clients is sort of, what is your goal? Do you want to get out of the lease? Do you want to, pay your rent and stay in the lease? Do you want to enter into a new lease? And I think those considerations all matter when negotiating with your landlord. I'm of the belief that friendly negotiations are always the best negotiations. So unless you're already kind of in an escalated situation with your landlord, I would always try to just reach out informally at first, through phone, in person, or and also through writing. So it's very important to get things in writing. So have an email, have letters. That's very important to show that there has been effort. And I see this question here. You don't get a response for landlord. Yes, so that's tough, having no response from landlords. And I think that's the toughest situation when you're trying to negotiate, when the party is not there to negotiate with you or doesn't decide to. And in that case, I think that's where you use some of the leverage that you might have outside of your legal rights. Unfortunately, in California, commercial tenants don't have a whole host of rights. And so what I always try to emphasize when I talk with clients in similar situations is figuring out what other leverage you might have. Like, is your business the only business of its type in the specific commercial area or building? Do you have a specific clientele in your business that could speak to the landlord? Is the commercial market that you're in right now, could you show to your landlord market analysis showing that if they were to evict you or fail to negotiate with you, they could lose more money like in the long term and not being able to fill their space or not being able to have a comparable lease agreement with a new commercial tenant? And I think all of those like different angles should be explored. And when you have a landlord that refuses to respond, sometimes if it's an egregious landlord that has specifically, I think, ignored different tenants, and if you can prove or show, like Julie said, that maybe there's some discrimination or something that could be used to, for lack of a better word, shame the landlord, I would say like worst case scenario, last resort, you could also kind of gather community support to engage in those tactics. And I've seen that before. There's a former client of mine was in a building, and the landlord was particularly egregious, where the landlord refused to negotiate, refused to make repairs. And the community rallied behind the specific business that was very community centered, run by a nonprofit. And they were able to create a campaign to actually partner with a nonprofit community land trust to buy the building from that particular landlord. And obviously that doesn't happen every day. It's a kind of like an exceptional case or scenario, but it is a great example of the creativity you can use in negotiating with your landlord and thinking about the different levers you have. With that, I'm looking at time. I want to give the time back to Julie, but those are just some like broad strokes. Again, feel free to go through the referrals that Julie had showed on the presentation if further consultation is needed.
Thank you so much, Jasmine. I just want to say a couple words and then I'll hand it over to Roger from CIS, who also wants to talk about their negotiation strategies that have worked. Iris, I think, it's important to emphasize that, as Jasmine said, taking a tenant to court might be a waste of the time and all the monetary investments. It's such a lengthy process, such an expensive process. And if at the end of the day, the bottom line is the business does not have the money to make the landlord whole. And that's important to emphasize. If their only option is going to be to declare bankruptcy, it's actually in their financial interest to negotiate and get some of the money back. And we've seen one strategy that worked is to extend the lease. So the tenant will say, I just need some more time. My business has literally been shut down or functioning at such low capacity. So if you extend the lease another 3 years, give me a chance to get my business up and running, and then I'll pay every month, I'll pay full rent plus contribute to the back rent. That's actually in their financial interest rather than trying to evict you. So try to reason with them and just point out why it's actually in their interest to negotiate. And I will hand it over to Roger for the next 5 to 10 minutes. Roger, would you like me to share the presentation, or do you just want to talk for the next few minutes?
It might be easier just to kind of dive straight in if you're going to be distributing the information,
okay,
Julie.
Sure.
So it's great to be here. Thanks everyone who's joined us and for everything that's been shared already. My name is Roger Moss, and I'm with the Conflict Intervention Service, which is a program operated by the Bar Association of San Francisco. We exist to prevent homelessness and also loss of locations by businesses. And our services, so we have a residential side and a commercial side. And our services, if you're in San Francisco, they're free to the vast majority of people that come looking for help. It's very rare that someone doesn't qualify. But if you're not in San Francisco, or if for some reason you don't qualify for the free services, which are funded by the City Office of Employment and Workplace Development, we can still help you because we can deliver our services very affordably through another part of the Bar Association of San Francisco. So wherever you are, we give everyone a free consultation, and a big part of what we do is connect people to other resources. So please check in with us. And we like to say, if you're not sure whether or not we can help, call us and find out. And we work as professional neutrals. And what that means is when you're in a conversation with us, just like with an attorney, it's completely confidential. But if we get a conversation going with your landlord, everything that is done in that conversation that we manage is also confidential under the law. And that's really important because there's two big themes here. One is, under the umbrella of confidentiality, people can be transparent and honest, and particularly in business negotiations, particularly in commercial real estate negotiations, the more transparency, the more likely that problems can be solved. And that connects to what Jasmine was talking about, that the creativity that comes from collaborative negotiations. And I started my career in commercial real estate in San Francisco in 1986. I've been involved with several thousand transactions between San Francisco and New York and Honolulu, focused on making deals as a retailer, as a tenant, corporate tenant, not in a legal role, but in a business development role, opening stores. And I've also worked on the landlord side of the table. And the thing to remember is it should be a relationship. And these days, with all the trauma, it's very common for everybody to be frozen up, terrified. We're all traumatized by the last few years. And so we like to remind everybody all the time, and I'll say it for everyone at this moment, remember to breathe, take a deep breath. And I also want to remind you all that you are business people. And as someone who was a business person for 30 years until I became involved with this program, that's my life passion now, I know that there are tensions between tenants and landlords. I know there are real disputes. Sometimes leases are ambiguous. Sometimes there's a crisis like an earthquake or the pandemic, which was unprecedented. And so there's a lot of fear that gets in the way. But when we remember that the best way to solve problems is to come together and work together, amazing things can happen. And what we do is, by being there to manage the conversation from a place of professional neutrality, it greatly increases the odds of positive things happening. So always look at your situation more through your lens as the business owner and what's good for your business than other things. And so, for example, one of the things that we can help you with, if you're a retailer in particular, we provide not just structured mediation services, we provide communication coaching, we provide business analysis. We have people on our team who have master's degree in business administration. They're all very experienced real estate negotiators in a commercial context, and they help individual businesses look at their sales revenue and design repayment plans, or even answer the fundamental question, are we able to be back in business or not? One of the interesting things that we saw early on in COVID was some people who have always paid their rent on time and they had a successful business for years in the city, they sometimes showed up wanting to exercise their right to cancel the lease under the ordinance. And we would slow them down and say, gee, are you sure about that? You've been paying rent, you actually don't owe that much. Let's look at it. Let's look at things together and figure out what the pathway is for you. And we have had a number of situations where people came to us intending to close their business. We helped them revisit all the numbers. They saw with the right plan with the landlord, they could turn things around. And then we were able to bring the landlord in and create an arrangement where that worked for both sides. Sometimes it's necessary to bite the bullet and close your business. And in that case, having a lease termination agreement that covers everything, so you know you're not going to be sued later, is critically important to get if possible. And we've had a number of those. And again, with an emphasis on the transparency piece, you know, sometimes people are very reluctant to disclose their personal financial information in the answer to landlords' questions. In dealing with large landlords in particular, it is really necessary to do that in order to get a good deal. This is different from the objections that Julie was referring to in a lawsuit situation, but trying to get a negotiated agreement, being as transparent as possible, and looking at things from the standpoint of the numbers will almost always deliver a better deal for you and your business than not doing so. Let me stop there and see if there are any other questions that people have. Oh, one other really important thing I want to stress: call us early. The earlier you have some help. Over the years, the biggest negative impact I've seen on small businesses was the failure to get help, either from a commercial broker or a commercial leasing lawyer or somebody else, to navigate both the business negotiation and the separate legal document negotiation. So get help early, and you can come see us more than once. And I think I will stop there, except to say, everybody who asks CIS for help, and you'll be getting our information from Julie, is guaranteed a response no later than the next day. That's 7 days a week, 365 days a year. We're legendary for that. We usually get back to people within minutes, because we want you to know that we got your message and help is on the way. So thanks for listening. And Jasmine or Julie, if you have any questions for me to add to that, I have too much information, but I'm worried about time here.
Thank you, Roger. That was really helpful. And I'll also include CIS has a presentation that they put together that was really helpful with some more information and statistics about their success rate. So thank you for joining us today, Roger, and encouraging people to get the conversation going now, even before a lawsuit is initiated. Thank you everyone for joining today. Anna will be following up with a copy of the presentation and as well as the recording of today's presentation. So thank you, everybody.
Thank you, everyone. Thank you, Julie.
Thank you for your
Take care.
service, LSE.
Okay, take care, you too.
Bye-bye.
Bye-bye.